Welcome to this webinar on temporary layoffs. My name is Anders Sundstad, and I'm a lawyer in Advokatfirma Thommessen Employment Law Department. And with me is my colleague Alexander Refsnes, who is also a lawyer at the same place. In this webinar, we will focus on the rules and procedures for temporary layoffs.
During the pandemic, many businesses had to temporarily lay off employees as a result of the lockdown. We found that for many companies, things went a little too fast, which created noise and uncertainty amongst the employees, and which gave rise to disputes. The purpose of this webinar is to give you an overview of the rules and procedures for temporary layoffs, and to point out some of the pitfalls which should be avoided to hopefully prevent disputes from happening.
And here on this slide, we have listed the agenda for the webinar. We'll talk about the legal framework first. Then we will go through the various steps for a temporary layoff process, including the preparations, notification to the Norwegian Labour and Welfare Organization, NAV, consultations, general information meetings, selection of employees, notice of temporary layoff, and salary and social security benefits.
Here is an overview of the legal framework for temporary layoffs. With temporary layoffs, we mean a temporary reduction in the workforce for a transitional period. During temporary layoffs, the employment relationship is temporarily suspended, meaning that the employer's obligation to pay a salary and the employee's duty to perform work lapses during the temporary layoff period. The legal framework for temporary layoffs is somewhat fragmented and inaccessible, and there is no temporary layoff law that sets out all the rules and procedures for temporary layoffs. The rules concerning temporary layoffs are distributed among different sources of law. After the pandemic, however, a lot was written about temporary layoffs in various articles and on NAV's website, which makes the information a little bit more accessible to employers.
The rules and procedures for temporary layoffs are based on the collective bargaining agreements and customary Norwegian law. For companies that are bound by collective bargaining agreements, rules and procedures for temporary layoffs normally follow from that collective bargaining agreement. On the other hand, for companies that are not bound by collective bargaining agreements, the rules are based on customary law and the rules in the main agreement between the Norwegian Confederation of Trade Unions, LO, and the Confederation of Norwegian Enterprise, NHO, which is the most important source of law for how the company should proceed in order to temporarily lay off employees. The employer is obligated to pay salary for a period after the layoffs have taken effect and the employee no longer performs work. This is called the employer's obligation to pay salary during layoffs, or the employer period, and is regulated by a separate act relating to the duty to pay salary during temporary layoff. Since temporary layoffs mean that the employer's obligation to pay salary is temporarily suspended, the employees must receive income in another way. Employees who are temporarily laid off are normally entitled to unemployment benefits from the Norwegian Labour and Welfare Administration, NAV. The conditions for whether employees are entitled to such unemployment benefits and how much employees receive in unemployment benefits are regulated by the National Insurance Act.
Here we have set up an overview of the temporary layoff process step by step. The first step is the preparations, which includes an assessment of the need for and the conditions for temporary layoffs. There is also a requirement to notify NAV if the temporary layoffs concern 10 or more employees in the company. The temporary layoffs must be consulted with employee representatives, and information should be provided to all employees to ensure the most open and transparent process possible. Then there is the selection of which employees should be temporarily laid off. The selection process within the selection pool must be based on predetermined, objective, and fair selection criteria. A temporary layoff notice must also be given, and specific deadlines apply here. And we will now go through the procedures for the temporary layoff process step by step.
Correct. Then we'll start with the preparations. We would always recommend spending time preparing and planning the process. It is also important to consider whether the conditions for temporary layoffs are actually met. The temporary layoffs can be initiated when objectively justifiable grounds make it necessary for the company and when the need for workforce reduction is temporary. And justifiable grounds may be lack of work, loss of contracts or assignments, need for cost reductions, operational disruptions, and so on. These are also reasons that will typically be justifiable grounds for redundancies. But in the event of temporary layoffs, the need for staff reduction must be temporary. For example, the company must have a realistic expectation that operations will resume as normal after a period. For example, because the company knows that there will be a large customer contract in a few months, or the company can use the temporary layoff period to bring in more assignments, etc. If the need for staff reductions is permanent, on the other hand, the company must initiate a redundancy process instead of temporary layoffs. The requirement for a valid or justifiable cause also includes a requirement that the company first has taken steps to try to avoid temporary layoffs. We have listed some examples here on the slide, such as negotiating with new customers, reducing costs elsewhere, including, for example, talking to the bank, to the landlord, etc. And the objectivity condition also imposes requirements on the process, which we'll return to shortly. We see that some employers use temporary layoffs as an alternative to a redundancy process in the hope that employees will find other jobs and terminate their employment themselves. The company should, however, not initiate a temporary layoff process to make a later redundancy process easier. And from the time the company discovers that the need is no longer temporary for employee reductions, the company has a duty to take temporarily laid off employees back to work. The employer must then initiate a redundancy process and pay full salary while the process is ongoing and during the notice period. It will normally cost more money, time, and resources if companies try to hide a redundancy as a temporary layoff.
Now we would like to briefly mention the obligation to notify NAV. If the company plans to temporarily lay off 10 or more employees, the company must inform NAV about this. This is done by sending a digital message to NAV via their website. The notification to NAV shall be sent as early as possible and no later than at the same time as the employer summons the employee representatives for a consultation meeting. There are a number of topics that the notification to NAV must contain, which we have listed in this slide. But NAV's digital message also specifies the information that must be provided in an educational manner.
As already mentioned, the requirements to have objectively justifiable grounds for the temporary layoff also imposes requirement on the process. For example, there is a requirement that consultations must be held with employee representatives as early as possible. And as early as possible means that the company must consult with the employee representatives before making a final decision on temporary layoffs, so that the employee representatives have a real opportunity to influence the decision before it is made. For companies bound by a collective bargaining agreement, one must ensure that all affected unions are included in the consultations. For companies not bound by collective bargaining agreements, the company may, for example, consult with representatives from the Occupational Environment Committee, called AMU, the safety representative, or simply ask the employees to appoint 2 or 3 representatives to whom management can consult with. The consequence of not holding consultations is that the notice period, which is usually 14 days, does not start to run. It's therefore important to carry out consultations with employee representatives. We have listed the topics that employers should inform and discuss about here on the slide. Minutes of meetings with employee representative must be drawn up and must be signed by all parties. And in our experience, 1 to 2 meetings with employee representatives will normally be sufficient to close the consultations.
An important issue that needs to be discussed with union representatives or employee representatives is the selection of which employees will be temporarily laid off. The selection process for temporary layoffs is generally quite similar to the selection process in the event of redundancies. The selection must be objective, reasonable, and must be based on objectively and justifiable criteria. The selection of employees to be temporarily laid off is relevant if some employees, but not all, will be temporarily laid off. If all employees are encompassed by the temporary layoff, which for example was the case for hairdressers during the pandemic, who were effectively prevented from performing their work at a specific time, the selection of employees who will be temporarily laid off will not be problematic. The selection process and criteria for temporary layoffs and redundancies can be divided into the concepts of selection pool or selection circuit and selection criteria. The selection pool defines which circuit or group within the company the temporary layoffs should affect. The main rule is that the selection circuit is the entire company. This could, however, be narrowed down, for example, to a specific department or geographical location, if there are reasonable grounds for it. It is generally easier to narrow down the selection circuit in the event of temporary layoffs than it is in the event of redundancies. The selection criteria are the criteria used to determine which of the employees within the selection circuit who should be temporarily laid off. The selection criteria must be as objective and reasonable as possible. Common selection criteria, which are considered to be objective and reasonable if they're applied correctly, are seniority, meaning length of service in the company, competence or qualifications, and social considerations. Companies bound by collective bargaining agreements normally have a provision in the collective bargaining agreement stating that seniority can only be deviated from if there are reasonable grounds for it. In principle, seniority has an impact on both the choice of the selection pool and the weighting of and the selection criteria. Companies that are not bound by collective bargaining agreements are normally more free to determine the selection criteria, but seniority should in any event be taken into consideration. As temporary layoffs are temporary and often triggered by a sense of urgency, the companies have generally had somewhat more freedom in determining the selection circuit and the selection criteria in temporary layoffs than in redundancies. And there's no requirement for the company to agree with the employee representatives on the selection pool and the selection criteria. But an agreement between the parties is an advantage, both legally and practically. Our experience is that companies are well served by maintaining a good relationship with the employee representatives. This could make it easier to try to agree on the selection procedure and the requirements. Good collaboration with the employee representatives will often make the process faster and smoother.
And we are now in step 4 of the process, meaning plenary meetings or information to employees. This is not something that the employer is obligated to do by law, but we normally recommend that the company informs its employees about the temporary layoff process early on. The reason for this is that a very common objection from employees and employee representatives is that they have not been informed at an early enough stage of the process. And in order to avoid unnecessary noise and unrest, and for personnel policy reasons, it's often advisable for management to summon the employees to a meeting where the management explains the background for the temporary layoffs and why temporary layoffs are necessary. This should be done prior to handing out notices of temporary layoffs to the affected employees, and potentially also before the selection is conducted. At the very least, we recommend that employees receive an information letter or an email describing the background, what process that have been implemented, that consultations have been carried out with employee representatives, and the further process.
Now we will talk about the selection of employees to be temporarily laid off. After consultations with employee representatives have been completed and the employees have been informed about the process, the difficult assessments related to who should be temporarily laid off begin. As we have mentioned earlier, the selection of who is to be temporarily laid off must be objectively justified and based on predetermined selection pool and objective selection criteria. At this stage, the selection pool and the selection criteria have already been decided, so this step is about applying these criteria to the workforce within the selection pool. Since the selection must be based on factual and objective selection criteria, the factual basis behind the selection criteria must also be correct. Seniority is an objective selection criteria, and also information that is quite easily accessible to the company. In cases where there is a sense of urgency related to the temporary layoffs, which will often be the case, it could therefore be beneficial to base the selection of employees to be temporarily laid off on seniority. If the company has chosen competence or qualifications as the main selection criteria, the selection process could be a bit more complicated and time-consuming, as the employer does not always have the full picture of the employee's competence and qualifications. In order to select employees based on competence or qualifications, it will often be necessary to conduct a mapping process where the employer has conversations with the employees to ensure that the selection is based on a correct factual basis. In bigger companies with a wide selection circuit, such conversations are often time-consuming and less practical. Therefore, it is quite common for companies to base the selection on seniority as the main selection criteria, and to discuss necessary deviations from this criteria with the employee representatives. Some employers also choose to narrow down the selection pool to a specific department or departments that are affected by the temporary shortage of work or loss of contracts, etc., and apply the principle of seniority strictly within this department or these departments.
And now we're going to say a few words about the temporary layoff notice. After the company has decided who will be temporarily laid off, based on the selection pool and the selection criteria, as Alexandra talked about, a temporary layoff notice must be issued. The temporary layoff notice is necessary to receive benefits from NAV for the affected employee and serves as a temporary layoff certificate when the employee applies for unemployment benefits from NAV. As a main rule, temporary layoffs are notified 14 calendar days before the temporary layoffs take effect. The notice period can be reduced to 2 days if so-called unforeseen events make it necessary to suspend operations in whole or in part. And the term unforeseen events is interpreted strictly, and there's a high threshold for an event to be considered as unforeseen, enabling a shorter notice period. Fires and natural disasters are typical unforeseen events. In March 2020, when the pandemic hit Norway, the requirement of unforeseen event was fulfilled, but later in the pandemic, the event was no longer considered as unforeseen, and employers had to use the notice period of 14 calendar days. The 14-day notice period runs from the end of the employee's working hours on the day the notice is given. This means that if the temporary layoff notice was issued today, the first day of the 14 calendar notice period would be tomorrow. It is important to note that the notice period will not start to run before consultations with employee representatives have been conducted. It should also be mentioned that the employer must fill out a confirmation of employment and temporary layoff at NAV's website for each employee who is temporarily laid off in order for them to apply for unemployment benefits.
The temporary layoff notice has some formal requirements. Beyond the requirements that the notice must be in writing and dated, the temporary layoff notice is not essential for the validity of the temporary layoff. That being said, the formal requirements have an impact on the employee's entitlement to unemployment benefits, and we therefore strongly recommend that the formal requirements are complied with. Here we have listed the information that the temporary layoff notice must contain. The notice must contain information about the reason for the temporary layoff, the employee's name, date of employment or commencement date, and the position percentage if the employee is employed in a part-time position, the layoff percentage, meaning whether the employee is 100% temporarily laid off or less. Note in this regard that to be entitled to unemployment benefits, the employee must be at least 50% laid off. The start of the temporary layoff period and its probable duration. If the notice period is set to 2 days, the layoff notice must contain the reason for the shortened notice period. And the layoff notice should also include any agreement with employee representatives that temporary layoffs are necessary. In principle, the notice of temporary layoffs must be delivered to the employees personally, but it is possible to deliver the temporary layoff notice by other means if this is agreed with the employee representatives in the consultation meetings. For example, it is quite common to send the temporary layoff notice by email. If such notices are sent per email, we would recommend including a read confirmation in that email.
The final topics we will talk about are salary and social security benefits. After the temporary layoffs have taken effect, meaning from the time the employees are no longer required to perform work fully or partly, the employer is still obligated to pay salary for a certain period. We call this the employer's period. The rationale behind this rule is to make it somewhat costly for employers to temporarily lay off employees, so that employers will not exploit the opportunity to temporarily lay off employees. During the pandemic, the duty to pay salary in the employer's period was reduced to 2 days, but today it is 15 working days. For employees who work 100% Monday to Friday, this means that the employer's period is 3 normal weeks. The employer's period does not run while the employee is absent from work, for example, in the event of holiday or sick leave, in which case the obligation to pay salary is extended until the employee has returned from holiday or sick leave. An important point is that the employer's period is 15 working days, and that is linked to the employee's working hours. In the event of partial temporary layoffs, the employer's period is also extended in time. For example, an employee who is temporarily laid off 50% from a full-time position will be entitled to full salary from the employer for 30 days when the employer's period is 15 working days. The employee will perform work as normal for the remaining 50% of his or her position.
After the employer's period of 15 working days has expired, employees may be eligible for unemployment benefits from NAV. The terms and requirements for unemployment benefits are many, and we have listed them here on this slide. In principle, it is the employee's risk whether he or she is entitled to unemployment benefits, but this could be a factor that could influence the selection of employees to be temporarily laid off. Employees are only entitled to unemployment benefits for 26 weeks within a period of 18 months. After this period, the employer is obliged to take the employee back to work. If the need for staff reductions still exists, the employer must consider carrying out a redundancy process.
We thank you for your attention, and we hope that this webinar has helped provide an overview of the conditions and rules for temporary laying off employees. If you have any questions, please contact us on the email addresses or phone numbers listed on this or on the website. Thank you.